What is the power or authority of the debtor in possession to secure post-petition financing? Now, these have to be reasonable, necessary costs and expenses for the operation of the business and reorganization of the estate. And in order to secure that financing, they can grant priority of payment to any of these lenders. Now, there's a general rule in Chapter 11 bankruptcies that shareholders, the owners of the company, cannot receive any distribution from the reorganization or liquidation until all secured and unsecured creditors are paid in full. But what if it's a shareholder who wants to provide the new value to the corporation? Now, the court has to approve it, but the debtor in possession can grant priority to this shareholder who provides new value. Now, the extent of priority could even go further than the extent of the new value. It could even go for a greater value than they're actually providing to the estate. Now, if through these reasonable efforts, the debtor in possession cannot find anyone to provide the necessary financing for continued operation, in that situation, the court can authorize several other methods of granting, again, preference in payment to any lender so they can make certain that they're going to be paid. So if regular priority will not work, the court can grant super priority, which means priority of repayment of any advances in financing beyond any other administrative expenses of the estate. So it's superior to everybody. This is one method. Second method would be to allow the individual providing financing a lien on property that's otherwise unencumbered, allowing them a secured claim against unencumbered assets of the estate. So it would make them a secured creditor. And in other situations, if they can't find it any other way, you could even grant a junior lien status to this financier on encumbered property. So you got a secured party, a secured creditor out here who has a security interest in collateral of the estate and assets of the estate, but the collateral is worth more than the creditor's claim against the estate. Granting a junior lien status on this type of collateral to a new financier who's put new money into the company can limit the ability of this prior secured creditor to continue earning interest and having a secure claim to the value of that accruing interest in that collateral. So if this is going to happen, the court has to approve it, and the court will make the estate, the debtor in possession, provide some level of adequate assurance to this existing secured creditor that at bare minimum, they're at least going to receive payment of the current value of their claim against the collateral.